Hi folks, it's Kip from Malik and Malik. If you see my eyes watering, it's not because I'm crying because this YouTube video is so sad. It's because the pollen in Ohio is conspiring to kill me. For the time that I lived in California, I never really had this problem, but man, it's just kind of intense. So anyways, today I'm going to be talking about this case called Ottinger versus B&B Wrecking and Excavating. It's a recent Supreme Court decision. It was published on May 2nd, 2024. I'll put the case site, maybe a link to the case in the notes so you could actually read the case if you wish. But if you get anything out of this video, it's this, that little details have huge consequences in relation to your workers' comp claim. And that would be the case in this one. And what do I mean? So just a little bit of the facts of this case. So what it was a mandamus. And remember, we talked about it before, you file right to participate cases to court, and then and that would be right to participate, i.e. you're trying to get your claim allowed or you're trying to get an additional condition allowed, and you file those to court. And then otherwise, if you have a mandamus, I mean, if you have an extended disability issue, like you're trying to get comp or your PTD was refused, etc., that would be a mandamus, and you'd file that to the 10th District Court of Appeals. And that's what happened here. So we have this guy, Billy Ottinger, and he ended up falling from a roof and landing on his legs. Falling from roofs, they're always horrible injuries. If you're a roofer or you do anything where you're on a roof or going up ladders, just be super safe, because we see like just horrendous injuries where people are falling and whatnot. Don't want that to happen to you. But anyways, he landed on his legs. He was unable to move his legs, and then he regained some sensation following emergency spinal surgery, but he still continued to experience significant weakness and mobility in his legs. So what ended up happening is the claim was allowed, and it was allowed for two conditions. And the first one's incomplete spinal cord injury. And then the second one, this is important, this has relevance to this case, is it was allowed for paraplegia incomplete. So here, or his attorney, they filed for a scheduled loss award for loss of use of both legs pursuant to revised code 4123.57b. And I'll put the link to that code section in the notes. But he went ahead, his attorney went ahead and filed that award. And just to give you some context, scheduled loss awards they ascribe a number of weeks per body part, i.e., and then you can look at those weeks and that reflects some kind of dollar amount value. So for one leg, you're looking at 200 weeks of comp, and then the award is a total of $239,000. So you lose a leg, you get $239,000. So this guy lost both legs, $239,000 times 2. Granted, I'm 100% certain that this guy would prefer to have this have never occurred, and frankly, $239,000 doesn't seem like it's sufficient money to lose your leg, but that's what Ohio has decided. You go to different states, they ascribe different values to injuries. So he filed for this award, and then what ended up happening is I turned my page. A BWC nurse went ahead and reviewed the request, and this is key. And in the review that she performed to determine whether or not he should receive this loss of use award for both legs, she noted that his claim was allowed for paraplegia. This is important, complete. So not the allowed condition, not paraplegia incomplete, but paraplegia complete. So they issued an order, the BWC issued an order, and then the BWC granted that motion for the loss of use of both legs. And you'll have to excuse me, I'm actually at the Ohio State Fairgrounds, and the reason why is I'm doing an errand here. and it seems to be a lot of cars and stuff driving by, so I'm trying not to get hit in this parking lot. So anyways, so the BWC issued an order granting the motion for the loss of use of both legs. So a few months later, Mr. Ottinger, or Billy Ottinger, filed for PTD pursuant to Ohio Revised Code 4123.8.58C1. And this would be, in this case, you would be filed, he filed for what's called statutory PTD versus the usual way that you file for PTD. So, and statutory PTD is, if a claimant has lost the use of both legs, then statutorily, pursuant to that code section, they're deemed to be permanently and totally disabled. All right. So, and then they filed that motion. Billy's, Mr. Ottinger's attorney filed that motion, and then the staff hearing officer issued a tentative order granting statutory PTD benefits. So, so what ended up happening is once that was granted, the BWC filed an appeal requesting, well, they filed an appeal to that, and then they filed a motion requesting that that the Industrial Commission exercise its continuing jurisdiction based upon a clear mistake of fact in law and a clerical error. So BWC and I've pointed out what is the error in this situation. It's because the loss of use, the scheduled loss award, was based off of this nurse review who issued the order or opined that this guy had this loss of use of both legs based upon the wrong condition. Paraplegia, she noted that the claim was allowed for paraplegia complete, whereas it should have been paraplegia incomplete. Okay. So what ended up happening is the BWC's motion went to hearing, and the Industrial Commission, they granted the BWC's motion, and then so what ended up happening is his loss of use award was denied, and then they also had, in addition to that, they also had a doctor opine that as far as statutory PTD is not statutory PTD, and then they had a doctor review his claim allowances, and that doctor opined that Mr. Ottinger had not lost the use of both legs for all practical purposes. So with a scheduled loss award, you don't have to actually have like the amputated arm or the amputated legs. If the arm or legs for all practical purposes don't really function, then you could still file a loss of use application and be granted loss of use. But what ended up happening here is the Industrial Commission, relying upon this doctor's examination or file review, determined that no, one, the legs aren't amputated, and two, for all practical purposes, Mr. Ottinger has not lost the use of both legs. So again, that's a denied scheduled loss award. And I don't know how much money the guy received already because generally it's paid week to week. You could get a lump sum advancement, but that would be an overpayment if he did. So what ended up happening is, again, this is an extended disability type situation versus a right to participate. So Billy's attorney filed a mandamus appeal to the 10th District. And what ended up happening is the 10th District, surprise, surprise, affirmed the decision of the Industrial Commission, and then it went to Supreme Court, and the Supreme Court affirmed the 10th District's decision and ultimately upholding the Industrial Commission's decision. So I mentioned this term called, when the BWC requested this motion asking that the Industrial Commission exercises continuing jurisdiction. And so that's kind of like a special, that means something. Continuing jurisdiction is basically saying, hey, this thing was decided in the past, but it's been wrongly decided, and we want you to revisit this issue and relook at it based upon, you know, a number of things. So you could grant continuing jurisdiction on new and changed circumstances, fraud, clear mistake of fact, and error by an inferior tribunal. And injured workers use new and changed circumstances as well, and in requests that the Industrial Commission exercise continuing jurisdiction. You know, for example, let's say you're an injured worker and you're requesting comp, and comp is denied because the hearing officer finds that you know, your conditions have reached max medical improvement or wouldn't be sufficient to keep you off work, or whatever situation they're deciding based upon some medical report. And new and changed circumstances would be, oh, well, it was allowed for a sprain before and you denied it under a sprain, but new and changed circumstances exist in that you have a herniated disc allowed, you have certification for that herniated disc, it's not been deemed to have reached max medical improvement. So those would be new and changed circumstances to grant a new period or a period of comp, possibly going back retroactively. But those are so that's the basis of when the Industrial Commission can exercise the continuing jurisdiction. And what the court determined was that the BWC issued an order based upon incorrect facts. And they determined that there was a clear mistake of fact in law, i.e. the loss of use award was based on an incorrect diagnosis. And I'm going back to that paraplegia complete diagnosis, which the nurse at the BWC relied upon. And it really should have been paraplegia incomplete. And maybe, and the funny thing is, it seems like such a minor error. I mean, maybe not, because paraplegia complete, I mean, you're thinking the person's paralyzed versus incomplete. I guess it means they're not paralyzed. But I'm assuming the guy's mobility and issues were fairly significant. And I don't know. I'd be interested to see how bad his situation was, because I'm thinking if you're diagnosed with paraplegia incomplete, I mean, I'm assuming that still really means that you really can't use your legs that well. And why that's significant is the court, relying upon a 10th district case, you know, they go on to say, the Supreme Court goes on to say that a single mistake of fact or law is all that is needed to justify a court's continuing jurisdiction. So a single fact, and in this case, that single fact is the wrong diagnosis relied upon by the nurse at the BWC. Paraplegia complete versus what was actually allowed, paraplegia incomplete. So, point being is, you know, these workers' comp cases can twist and turn on the smallest facts, and it's kind of mind-blowing. And the really the shame or the issue in this case is, I mean, this guy doesn't get the $239,000. I mean, he was going to get what, 480 or whatever $1,000, and now he gets nothing. He might have an overpayment on his claim. Man, that's awful. And the other thing that's a problem is, I'm assuming, I didn't really catch it in this. I don't think they really discussed it, or I didn't catch it. But if the PTD, the statutory PTD, was relying upon the loss of use situation, then I don't think he's PTD either. So he has to go through all the hoops to be found PTD. You know, the usual hoops of being examined by a doctor, by multiple doctors, going to an industrial commission hearing possibly, If he's not medically PTD, then having to go through the Stevenson factors, you know, the age, the education level, job experience, etc. So again, little tiny details can have a huge impact, and for this guy, it had you know, a nearly $480,000 impact, and it's just it's, I don't know, that's kind of devastating for this injured worker. I hope he's doing okay, but man, anyways, but that is why you always I always recommend, I mean, I don't even recommend it, I'm telling you frankly, if you have a workers' comp case, you really do need a workers' comp attorney, because Ohio workers' comp law is incredibly complex and confusing, and it's going to pay you benefits to get an attorney involved. So I would ask your friends, family, coworkers, you know, who do you guys use, or who have you used, or who do you think is good, and go talk to that attorney, or Google search, you know, search on Google, find somebody. And if you don't like, you talk to one attorney, you don't like them, talk to another attorney. Find the right attorney for you. And remember, workers' comp attorneys, plaintiffs' attorneys work on contingency fee basis. So what that means is you don't pay them until the contingency occurs. So there's no hourly fees. So there's really not a huge downside to get an attorney involved. And again, I strongly recommend you do get an attorney involved. Nevertheless, please stay safe. And thanks for watching this video, and I'll catch you in the next video. Thank you. Attorney Kip, Malik and Malik.